No, the $100,000 H-1B rule is not an E-2 investment requirement. Every US visa begins with one of three ingredients: love, talent, or money. And today we are talking about money. There's a question I've been hearing constantly lately, especially after recent headlines about the $100,000 H-1B payment requirements. People are asking, does this mean I now need to pay USCIS a $100,000 fee for my E-2 investor visa too? The answer is no. And confusing these two categories could lead investors to make expensive business decisions for the wrong reasons. I'm Tapias, CEO and immigration attorney at Loigica. And in this video, I'll explain what the H-1B controversy actually is and why E-2 investors should not confuse that news with their own immigration strategy. First, H-1B and E-2 are completely different visas. Let's start with the foundation. H-1B and the E-2 are completely different immigration categories. The H-1B is an employment-based visa. It allows U.S. employers to temporarily hire foreign professionals in specialty occupations. Think engineers, developers, accountants, and other U.S. professionals working for U.S. employers. The E-2 is different. The E-2 is an investor visa. It allows entrepreneurs from treaty countries to enter and direct a business they have invested in. So immediately you can see the difference. H-1B is based on employment. E-2 is based on investment. So why did the $100,000 H-1B requirement exist? You may have seen headlines discussing a $100,000 H-1B payment requirement. That policy emerged during the Trump administration as part of a broader effort to increase scrutiny over certain employment-based immigration pathways and prioritize what the administration describes as higher value or higher wage employment. The policy became controversial immediately. And importantly, this was never an E-2 rule. It was tied to certain H-1B scenarios and became the subject of federal litigation. Recently, a federal judge initially struck down the $100,000 policy, but the government appealed. And as of now, enforcement remains subject to ongoing court proceedings. So if you are watching immigration news, be careful not to generalize one visa category into another. Why E-2 investors should ignore the myth. Now, let's talk about E-2. Under E-2 law, there has never been a mandatory minimum $100,000 investment. That number does not appear in the regulations. The actual legal standard is different. The investment must be substantial, and substantial does not automatically mean large. It means appropriate for the actual business. However, in practice, due to inflation in the United States, we do recommend a minimum $100,000 investment to help meet the substantial requirements. A consular officer will want to see that there is enough funding for a company to be successful. But different businesses will require different substantial amounts. For example, a car wash business and a car sales center are not judged the same way. The government generally evaluates things like total startup costs, capital actually deployed, whether the funds are truly at risk, and whether the business can realistically operate. So a $100,000 investment could, for a small business, sometimes be stronger than a $100,000 investment for a larger business. The mistake investors make is assuming immigration works on magic numbers. It does not. The H-1B debate is about one legal category. The E-2 analysis is completely different. For E-2 investors, the real question is not, did I spend $100,000? The real question is, did I build a business structure that actually satisfies the law? If you're considering an E-2 E-2 investment and want to evaluate whether your business structure actually supports approval, our team can help. We analyze proportionality, source of funds, deployment, strategy, and long-term business viability before filing. And remember, every US Visa story begins with one of three ingredients: love, talent, money. I'm Tapias, and I'll see you in the next video.